Hi, this is Rahul Reddy. We are here live from Houston, Texas. REDDY NEUMANN PC brings in immigration information every Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily.
Thanks for joining us this afternoon. Today we're going to be talking about the cap gap for those that are on F-1 student visa with an OPT that has expired over the summer, and what you need to know about when that cap gap ends, what steps you need to take. And also we're going to be talking about situations where your cap subject H-1B has been denied, what options you might have in order to overcome that situation. We have some updated statistics from the Department of Labor regarding perm processing, as well as LCA details for H-1Bs. And we also wanted to talk about kind of a relatively recent trend we're seeing in some H-1B petitions where an extension is being filed, or sometimes even in cap cases, the petition is being approved for less than the 3-year period requested. And we have some thoughts about maybe what we can do to overcome those situations as well.
Emily, on the cap gap, I just want to explain what a cap gap is, that when your EAD or STEM extension is expiring between April and October 1st of 2019, and you file a H-1B for a change of status and you got selected in the lottery, you are allowed to work until October 1st of 2019, or your H-1B has been denied. If the H-1B is approved, you can continue working. If the H-1B has been denied, you cannot continue working after the H-1B is denied. Now, if the H-1B is still pending and it crosses September 30th, you can stay in this country, but you cannot continue working on your cap gap that expires on September 30th. Emily, what is the trend that you see? Is the USCIS adjudicating the applications in a proper timing?
I think it's a little bit better than last year, but that's mainly because we had premium processing this year where we didn't last year. But we still have a number of petitions where no action has been taken by USCIS. And it may be necessary, now's the time, if you are not already in premium processing, to consider upgrading because you have the 15-day calendar day processing time from the upgrade, which is going to put you at this point mid-September to get your approval or to get a request for evidence. So at least if you get that approval by mid-September, late September, then you can continue working without any gap in employment authorization. But if yours is delayed beyond October 1st, you have to stop working.
Emily, on the options of the H-1B getting rejected in the lottery, there are two reasons what I've seen mostly getting H-1Bs rejected in the lottery. One is that the H-1B is rejected because the USCIS thinks that there is no employer-employee relationship. Then I have also seen the H-1B getting rejection because the USCIS feels that the specialty occupation, the specific degree, is not required for the position. Now, these are the main things. Of course, there are other issues that you see the denials. Now, what solutions do you have? Is it better to file a motion to reconsider, appeal? What other options that they have?
Yeah, I think that's the difficulty with these cap cases is you can't just turn around and refile it. You have to, because you've not been counted in the cap. If refiling is your plan, you have to wait until next April, hope you get selected in the lottery again, file again, and then try your chances next year. Other than that, your other option is to file an appeal. That goes to the Administrative Appeals Office. You can file a motion to reopen or a motion to reconsider, which is very similar to an appeal, except that it doesn't go to the Administrative Appeals Office. It stays directly with USCIS. And so if that gets denied, an appeal would be your next option there. What we're looking at this time around is the potential of filing a lawsuit in the event of a denial. You don't have to file an appeal with USCIS or the AAO. You can go straight to federal court and argue that the denial was arbitrary or capricious or in violation of the Immigration and Nationality Act. And so I think we're going to see a lot more situations this year where litigation may be the best option. It may be a faster option. Typically, once you file a lawsuit, the government has 60 days to respond. Sometimes during that 60 days, they might reopen the case and come to a different decision. You compare that with the AAO, the Administrative Appeals Office, it takes 6 months for them to review. It might be April of next year before you get a decision from the Administrative Appeals Office. So that's one huge advantage.
What is the statistics, Emily, when you go to the litigation? Now we have you have Jonathan Watson as one of the team lead for you for the litigation, who's very experienced in it. What is the statistics that you have when, if I were a student, I got my H-1B denied, if I go to the Administrative Appeals Unit, what are my chances of getting the approval as compared to going to the litigation?
Yeah, they're definitely better. Can I give you exact statistics? No, I can't, because it really does depend on the specific facts of each case, and each case may have a different issue that caused the denial. What we do know is the Administrative Appeals Office, the success rate there for H-1B denials is 3% or less. So less than 3% of H-1B appeals actually get overturned by going to the Administrative Appeals Office. So I'm relatively confident that litigation is going to have a much higher success rate. And oftentimes the case gets reopened by the service center and a new decision issued before the litigation has to move into arguments or anything like that.
Emily, I will ask you more questions about what are the drawbacks of the litigation, but I want to give the audiences the clear picture. What's the basis for which we are litigating? As we have discussed before, there are two reasons why the rejections are occurring. One is that the rejection is occurring because the USCIS doesn't think that employer has the control over the employee and there is no employer-employee relationship. Now here is where the weakness of the immigration seems to be. They are not following the regulations which were issued by them. According to the regulations issued by them, the H-1B position the employer must have right to hire, right to fire, and must pay the salary. These are the three absolute requirements that need to be there. Now, if any of these three requirements do not meet, then they have to go to the alternative requirements or otherwise control. USCIS did pass memo in January of 2010. They did pass memo in February 22nd of 2018 describing or otherwise control in very detail. Now, when we go to the H-1B, they are reading the regulations or as and. They are not reading as or. It's hire, fire, and pay. These three requirements, or the employer should have otherwise control over. They're completely ignoring the hire, fire, and pay. They're not asking a single question on hire, fire, and pay, and they're just going or otherwise control. But if we meet the requirements hire, the employer has the authority to hire, employer has the authority to fire, employer is obligated to pay the salary, they meet the requirement, the USCIS is not following its own regulations and issuing a memorandum which is completely contradictory to their own regulations passed. Now, of course, in the regulatory process, there are certain requirements that they have to go to by a government officer issuing a memo contradicting the regulations that have been passed through the proper source. What chances are there when we go, when USCIS ignores its own rules?
Yeah, I mean, it's very clear that they've played around with the words here. So I'm going to give you the exact wording of the regulation itself and how USCIS changes it in their request for evidence. So the regulation says that in order to be considered an employer and be eligible for an H-1B, there must be an employer-employee relationship as indicated by the fact that the employer may hire, pay, fire, supervise, or otherwise control the work of any such employee. So the supervise and otherwise control is or, and it's at the end. This is how they change it in the RFE. They say, to qualify as a U.S. employer, you must establish that you have the right to control the beneficiary's work, which may include the ability to hire, fire, or supervise the beneficiary. They don't even mention pay.
Yeah.
So they turn the regulation completely around. And I honestly don't know how they've been getting away with this for so long. But I do think that any court, when you're looking at the construction of the regulation, you can't insert an and when they put or. If they meant to say and, they would have said and. They didn't. They had their chance when they issued the regulation, and USCIS's interpretation of it completely modifies the spirit of the regulation.
Yeah, spirit of the, and in the USCIS website also, though in the question and answers with regards to the memos, they clearly mention that it's the hire, fire, and pay or otherwise control the employee. They're just going otherwise. I mean, it's just crazy. I don't think so any federal court judge will approve any of these tactics what they're using. I think so that if you guys get your H-1B denied, my suggestion to you is that to go for the litigation process, you have a better chance of success than compared to going. Emily, having said that, litigation means people are fearful. What's going to happen? I mean, is that something people they need to be scared about? Well, the USCIS has come back like the Saddam Hussein kind of thing where the dictator, is this going to happen in this country, or what do you that's a fear a lot of people have.
Yeah, I think both from an employer and an employee standpoint, people are fearful of litigating. One of the common questions we get is, if I file a lawsuit, now they're going to do all this discovery process and ask me to provide all these records of past filings and all of, open up all of the company records, open up everything related to the employee, and that's just not the case. When you go to federal court litigation, the only evidence they have to go off from is the record. That's what's been submitted to the Immigration Service and what the Immigration Service sent back to the employer. So they don't open it up beyond the evidence that's already in the record in order to make a decision. And from an employee standpoint, if I'm suing the government, are they going to retaliate against me later? Are they going to deny my green card or deny my extension or something in the future because I've sued the government? And the answer is no. That would be against the law for them to do that, and it just doesn't happen. If anything, you have the opposite effect where the USCIS is a little more careful before they issue decisions in the future on cases involving that employer or that employee.
Emily, one of the aspects is that litigation means it's a very costly affair. So since it's a costly affair, what is your law office doing to cut down the cost? I mean, to go to the federal court in front of a judge that's appointed by the president of the country, was been ratified by the Senate. It's not that easy for people to do it. So what is your office doing to cut down the cost on it? Yeah,
we found that if we have multiple employers that have the same issue, we can combine all of their cases in one litigation, one complaint, and file a lawsuit at one time, rather than filing individual lawsuits in different courts across the country based on wherever the employer and employee are. And so this has really cut down on the cost and the expense associated with litigating these cases. So whenever we have the situation where multiple cases, even from different employers, different employees, are denied for the same reason, we can group them together and file one lawsuit to reduce the cost.
Emily, on the perm thing, labor statistics, what did we get in the perm statistics that you got it right now?
Yeah, so the interesting thing is we have comparison from last year to this year. So this is fiscal year 2018 to fiscal year 2019 so far. And the number of perm filings has stayed relatively stable, like 0.6% change from one year to the next. So the number of filings are the same. The number of denials has been relatively steady. And what we do see is still the large number of perm filings are in the computer professions, computer occupations, and I think about 60% of all perms filed are for positions in computer or mathematical occupations. And we also find that still about 68% of the perms filed are for those that are in H-1B status. And about half of all perms are filed on behalf of citizens of India.
Indian nationals, yeah.
And also about half of them are filed for advanced degree petitions, which generally relate to EB-2. So about half of all I-140s that are going to be filed based on these perms are going to be EB-2 petitions. So it's been about the same for the past several years. So that's one I guess, silver lining in all of the changes with immigration is perm has been relatively stable. We also have statistics from Department of Labor on the LCA, the labor condition application, which is submitted with every single H-1B filing. And the same thing here, the percent change of the number of LCAs filed last year to this year is only 2% increase. So that's about the same. Interestingly, we still have the vast majority of the LCAs are for software developer type positions. There's a number that are still filed for computer programmers, which I find interesting after the computer programmer memo was tossed out a couple of years ago. So yeah, things are relatively the same as far as from the
unlike
labor.
the H-1Bs and other things, yeah.
From the Department of Labor
Now,
standpoint.
coming back to the H-1B topic, Samli, there is a 25+% of H-1B denials right now, and especially now that goes up for the consulting companies where people are working at the third-party location. Now, we have seen an increase in the denials since this administration comes in. Now, even if they are approved, some of the H-1s are getting approved for 3 months, 6 months, 1 year. Recently, we have noticed that some of the approvals come in. The approval comes in on August 15th, but approval is only until July 15th. What's the solution for it? Anything that you can do? Can you go back to the USCIS? Look, correct the approval. You only gave it until July 15th. You gave an approval on August 15th, but the approval end date is only July 15th. Does it work, or is there any solution?
Yeah, I mean, the difficulty here is USCIS approved the case, and so it's not a denial that you can appeal, so you don't have the option of filing an appeal. We used to, for premium processing cases specifically, have the opportunity to email the premium processing unit and ask for a supervisor review. They stopped allowing that about 6 months ago, so we can't even do that. So your choices are file an extension, again, after you just filed one because it was only given for such a short period of time, and many times this extension ends up being filed late because the approval's already expired by the time you get it in the mail. So then you have to make a nunc-pro-tunc argument, basically explaining that the failure to file on time was due to extraordinary circumstances beyond the company's control, beyond the employee's control. So up until now, those have really been the main options. But we've been exploring a lot of different areas in immigration where litigation might be a better option. And the reason here is when the Immigration Service issues an approval for less than the time period requested, they're in effect denying part of your request. So they're approving it in part up to a certain date, and then they're denying everything beyond that date. When they do that, under their own procedure, they're supposed to issue a decision explaining why they denied the rest of your stay. We've never ever had that kind of decision mailed to us along with one of those approval notices. 50% of the time, you can't tell where they came up with the date. It's just a random date, like they threw it on a dart at a calendar. Yeah. It has nothing to do.
They might have it in their lunchroom.
Yeah, nothing to do with the documents that were submitted. Sometimes it's a day, sometimes it's 3 months, sometimes it's 6 months. Sometimes it matches some document that was submitted, but not realizing that those documents get renewed quite often. So in that situation, what we're looking at doing, this is preferably in the situation where you receive this shortened approval early enough before it expires. So if you have a short, for example, you filed an extension, you got the approval, but it's only valid for 6 months. So you have 6 months before you have to take any action. In that situation, we can file, again, a lawsuit in federal court pushing back on these short-term denials because USCIS is not following its own procedure in explaining the reason for these denials. And even if they do, there's nothing in the statute or regulations that supports them having the authority to give shorter approval notices. They're supposed to give up to 3 years as long as you haven't hit your 6-year limit. They're using that up to 3 years to say, we can decide anything less than 3 years whenever we want, even if you're not reaching your 6-year limit. And so in that situation where you've gotten a shortened approval that has time on it, maybe 6 months, even a year, we can file a lawsuit with enough time, get a result from the court, hopefully within 60 days, and then get you a 3-year approval, and avoid the need to have to file an extension 6 months from now or a year from now. So every time you're filing that extension, you have to again satisfy the Immigration Service of
the whole 9
the
yards.
whole everything, your qualifications,
vendor
the
letter.
specialty occupation, all the letters and everything. And so if you can avoid having to file multiple times within the same 3-year period, it's obviously a cost savings from a legal fee and filing fee standpoint, but it's also just the less stress you have to deal with. There's so much uncertainty every
Especially
time
with
you
the driving
file.
license, if you're eligible for H4 EAD. It's, guys, they're approving for 3 months, 6 months, 8 months, 12 months, whatever they feel is right. I mean, somebody need to challenge us. As Emily pointed out, the regulations are very clear. If there is a partial denier, that means that if I ask for 3 years extension, they only give me 6 months or 1 year. They have to give an explanation. Now we know that they may be looking at the inclined letter, which is actually not legal. They may be looking at the vendor letter, which is actually not legal. They need to look into the LCA signed by the employer who is willing to pay the salary for the 3-year period. Now the only time they should actually reduce the time is either the employer did not request or you're not eligible for 6 years. For example, if you have completed 4 years of H-1B, you don't have a labor and I-140 approved or pending, yes, you may be eligible only for 2 years. Under those conditions, yes, they have, they do have a right to squeeze your H-1B approval only into 2 years. They don't have any authority and they're doing it. All these things, we have been, silently doing it, filing the extensions, filing the amendments, filing all the, every time we file, we need to extend the H4, we need to extend the EAD, and that's taking a long period of time. We have to challenge too. Now, Emily and I, we sat down together entire with the office. We thought that with 25% denial, and then we do represent software consulting companies. I'm not telling that we are great. We get every of our H-1B approval. I mean, we do get our H-1B denial sometimes, and it happens. And based on different things. When the approval comes in, it's a short period of time, then we go file the extension, then we get 6 months, we get these things. Every time we go, we recommend people to get the decision before their I-94 expires, because there are other options that may be available if I-94 doesn't expire. So this is going on, and we decided, no, let's go to the federal court. And then federal court is a costly affair. I mean, it's not going to be an easy thing. The lawyers are costly. So what we decided is that to club the clients together, and if they all fall into the category where the H-1B has been applied for a longer period of time and their H-1B has been cut down to a shorter than the period the employer requested, and they're eligible for until the expiry. I mean, if their 6 years has not been expiring until that time, you will be eligible for the litigation. We are taking up these things. It's going to be cheaper for you to go through, or your employer to go through this option rather than actually keep on filing the extension. If you're interested in, please contact any of our office people. We'll go through those things.
All right.
Emily, let's go to the question and answers. We do have a lot of questions today.
All right, so we have a question from YouTube here about validity of I-140. So company A filed an I-140, and we have, I'm assuming, an H4 EAD based on that. And now the company's been closed for whatever reason. And what is the status of the green card process in that I-140? So so I'm assuming that the EAD is based on an H4. Maybe it could be based on a pending 485. Those will have different answers. But the short answer is, if the I-140 has been approved for at least 180 days and then the company closes, the I-140 remains valid for you to be able to continue to get H-1B renewals, to continue to get H4 EADs, and to port the priority date. Now, if you've already filed your 485 and it's been pending for at least 180 days, and then the company goes out of business, you're eligible to port your entire green card process with you to a new employer at any time, as long as the new job is in a same or similar occupation category under AC 21. So it really depends on where you're at. Have you filed the 485 yet or not?
Narasimha Naidu from YouTube has this question. Can you file a H4 EAD based on the wife's H-1B receipt notice? My H4 status is still pending approval. Yes, you can file a H4 EAD while H1 and H4 is pending. Absolutely not a problem. you can do so. It would have been better had you filed EAD together along with the H-1B, but yes, you can file. You can file. Ranjit has this question from YouTube. Is it possible that the USCIS might deny change of status from F1 to H4 when he is moving from day 1 CPT? Yes, it is possible that the day 1 CPT people may be denied F1 to H4 status. It may be denied because a lot of the day 1 CPTs are not considered to be legal. We have already noticed significant of H1B, F1 to H1 getting denied. You may want to consider going outside to the outside and get the stamping done. Rajesh from YouTube has this question. I have a fiancée. I'm about to get married. She's a U.S. citizen. How long it takes for people to get a EAD and green card if you're an Indian citizen? This is the one thing, if you're an Indian citizen, it doesn't make any difference whether you're an Indian citizen or not. If you're marrying a US citizen, the green card is taking approximately around 18 months. The EAD, which used to take only like 90 days, is taking approximately 6 to 8 months. Everything this administration is intentionally delaying these applications, guys. And when we go to the federal court, which we did in H4 EAD, all the cases that we filed got approved in 60 days since we went to the federal court as of now. Most of them get approved between 30 to 40 days, but yes, there are some cases that are taking up to 60 days when we go to the federal court, and this is happening very frequently. We're filing almost like more than 30 to 40 litigation files in the court every week now. That's a big number compared to previously. I mean, in 2018 we are not doing it, but we are cornered. I mean, nothing. The USCIS delays everything, denies when they're eligible for. So litigation is a source right now, and we have brought down the cost of the litigation. That's the one REDDY NEUMANN PC did very good. No, I don't know of any other firm, but we are the only law firm that brought down the cost of the litigation by clubbing up. So what we do is that all those people that fall into the category will file in one litigation.
All right, Matthew from YouTube has a question, and this is comes up quite a bit now because of these EAD delays. And he wants to know if the spouse files the H-1B in premium processing and gets the approval, can the H-4 holder go to their home country or go outside the U.S., get the visa stamped, come back in to get the H-4 extension that way, rather than filing the I-539 and then apply for the EAD? The answer is yes, you can definitely do that. Part of the reason for the EAD delays is the I-539 delays. So you're avoiding the I-539 delay by doing it that way. However, just as Rahul said, the EAD by itself can take 6 to 8 months depending on which service center it goes to. So processing times are slightly better when the EAD is not dependent on an I-539, but it still may take some time. But definitely file early and travel early if you're going to do that.
Emily, any predictions on the EB3 priority dates, Emily?
Oh, I have no idea. I think
we are not expecting much movement in the EB3 priority dates at this point of time. So don't expect a miraculous things going on in EB3. The only hope is the Senate 380C bill to be passed, but nobody is discussing about that bill, Emily. That had a lot of attention before, but nobody's talking about it. I request all the people to write letters to the senators to pass the Senate Bill 386.
Sullivan from YouTube asks if changing an employer shortly after getting the green card can cause any problem when you're later applying for your citizenship. In this case, he's saying just a couple of months after. So there's kind of a rumor out there that says you need to stay with an employer for 6 months after you get your green card before you move on to a different employer if you receive your green card through an employer sponsor. That is not a real rule. It doesn't exist. And what they look into is, did you intend to work for this employer that sponsored you, and did that employer intend for you to work for them? Or did they just sponsor you just for you to get the green card? So I think generally in the situation where you've worked for that employer throughout the process and then stayed for a couple of months after you got your green card, I don't think I've ever seen that come up at a citizenship application. Amit from Facebook has a good question. In the situation where the student is on F1 with a STEM OPT, so they have potentially 2 years of OPT time, do you have the option to file the I-140 and 485 concurrently if the priority date is current? Is that a good idea? It can be. Obviously, that will speed up the time of getting the EAD approved and getting the green card approved, so you hopefully won't run out of OPT time. But I would want the I-140 to be reviewed very carefully. If there's anything risky in the case, anything that could potentially cause a denial, it would be better to file the I-140 first, make sure you secure the approval before spending all the time and money on filing that 485.
Emily, I have a good question from Saurav from YouTube. What he's asking is that to improve the career of a person, they may have to do blogging, they may have to create videos, they may have to market themselves out. I mean, it's not just market themselves out, to even survive in a job, people may have to do it. And that's what you and I am doing it too. Now the question is that can a H-1B person, to improve his ability or his marketability or his even doing his job, can he do that thing? Is it legal? Is it frowned upon? That's the language Saurav has used in the YouTube.
Yeah, I think it depends a lot on the situation. You know, if it's something that you're passionate about and you're just doing it as a hobby and it happens to improve your career,
he's not
maybe.
speaking. What if it's improving the career? What if that is a requirement of the job that you probably need to do that? I mean, does it mention in the job duties in the H-1B that you filed? Did we, when you joined this job, did we ask you, are you going to have a YouTube? I don't think so. YouTube existed.
And I doubt that's a specialty occupation either, level position. So yeah, and I think definitely if you are earning some sort of side income from that, I think that's a major problem.
But I think so that Saurav, if he is doing it as a part of the job, you know, nowadays, there are a lot of things. I mean, when customer comes in, you go and ask, can I have a can I serve you a coffee? Is that a part of the lawyer's duty? No, it's not. I mean, there are some side things that people are allowed to, according to me, that are incidental to the job duties of what they are doing. And if they're incidental, nowadays, blogging, YouTubing or Facebooking, as for the business purposes, is an absolute essential. Just like the way it might even bring some business to the clients, like the way it happens with us. I don't think so. It should be frowned upon. That's my opinion.
Yeah, I think it also depends on whether you're doing this as part of your current position, or you're doing this on the side in order to advance to a different company, or
Let's say I want to advance to a different company.
I think that's different than what you mentioned about me going and serving someone coffee.
I got it.
Because that's my employer is telling me I need to do that.
So in other words, if I'm getting a certificate, where I want to improve my skills, is there anything wrong? He's not making any money.
I think a certificate, is probably fine because
now the new age.
But that's education. You can go to college on the side and still be maintaining your H-1 status.
Well, reading the notes from the people, it's education for us too. That's the way I feel. We may disagree on it, but it's a good thing. I mean, I think so that he should be fine. That's my opinion. The question that came from Nilesh from YouTube is, how easy for non-exempt physical therapy extension chances for approval with the same employer? Physical therapy should have a good chance of the approval, especially when it comes to the specialty occupation, though. It should meet the requirement, Nilesh, because physical therapist requires, according to license, at least a bachelor's degree and in most of the cases it's either a master's degree or a doctorate degree nowadays in some of the states. So it should especially meet the specialty occupation. But when it comes to the employer-employee relationship, if you're working at a third-party location, Nilesh, we are seeing some pushback from the USCIS, whether it's your employer that is controlling, and according to their regulations, you should be controlled by your employer, but now they're not going according to their regulations. They are going there by their own, they're violating their regulations sometimes, asking those questions and denying those H-1Bs, but mostly specialty occupation wise, you should be fine. As far as the employer-employee relationship is concerned, you should have a proper documentation if you're working at third-party location, Nilesh.
Praveen from YouTube asks if the H-1B lottery selection process is at all dependent on the occupation code. His sense is that people that have software developer as their code tend to get picked, have a better chance of getting picked than people, say, data analyst. And no, they don't even look at any of that before they run the lottery. It truly is 100% random. I think probably the reason why you're seeing a difference is just the vast number of people that are filed under software developer versus data analyst. I mean, software developer has 2 different codes, and those 2 codes combined are 40% of all LCAs that were filed last year.
Wow.
So there's just a high number of people that use the software developer code in their CAP filings. So of course, you're going to hear about more people getting selected in that category.
Prachi from YouTube has this question. I'm an Indian citizen, approved I-140. If I move to Canada, what will happen to the I-140? Prachi, if it's been more than 6 months that your I-140, 180 days that your I-140 has been approved, the I-140 is still valid for the purpose for you to come back on H-1B. If you are on H-1B at any point of time, you are not subject to CAP at any point of time. When you come back, you can port the date to a new employer, or if you still have the valid job offer with the same employer, you can come back and join you can come back and join if the prior date is current. You can apply for the adjustment of status. One thing I can tell you that if you're born in India and you're going to get a Canadian citizenship, you will not be counted towards the Canadian CAP. You will still be counted towards the Indian CAP. That's one thing that I want you to be careful about.
Bharat from YouTube has a very common question. So he's got an I-140 approved with company A, has filed a transfer to company B, and now transferred to company C, and has a 3-year approval notice on that, and wants to know, does he need to start the green card process during this next 3 years, or can he wait and do it later? So this is very important to understand that once the I-140 has been approved for 180 days, you can continue to use that I-140 to get 3-year H-1B extensions with any employer, and you do not need to start the green card process in order to with that current employer in order to extend again. You can keep using the old employer's approved I-140 to extend the H-1B with any employer, but in order to finally file your 485 when your date becomes current, that's when you need to have the new labor and I-140 in place.
Between H4 EAD, F-1 visa, which one would be the right path for graduate students? The easiest way, I mean, this is a personal question, I would take it, not legal question. If I were you, I would take the H4 EAD option over F1, because F1 visa has a lot of restriction, OPT STEM extension has a lot of restriction, H4 EAD has no restrictions at all. So I would choose it. What do you choose, Emily?
Yeah, I agree.
The question comes from Matt from YouTube as this question. Can an I-140 prior to date be ported from company A to company B when the job duties of company A and company B is different? Absolutely. You can port the date. Even if the job duties are different, it's not going to be a problem for you to port the date.
Yeah, the job duties being the same is only relevant when your 485 has been pending for 180 days and you're trying to take the whole green card process with you to the new employer. Otherwise, for just porting the date, it doesn't matter at all. Another question from YouTube. This individual has been on L1A and has finished 3 years, but also has a CAP case in the H-1B that's approved and valid until 2020. I'm assuming that that was approved consular processing, otherwise you would be in H-1B status by now. So he wants to know, if he doesn't activate it before 2020, is it possible to extend the H-1B beyond that? The answer is no. Without actually getting the H-1B visa stamped or being admitted to the United States in H-1B status, you're still not considered counted yet. So it'd be very important, if you're ultimately planning to switch to H-1B, to get that visa stamped before that petition expires so that you don't lose your CAP number.
One question that came out from Jyoti is that she doesn't have a work permit. Can she work for a nonprofit organization? It depends on if your intention is for a future employment, that you intend to get the job from there or the similar profession. I take back on the similar profession. If your intention is to get a job with the same organization, you cannot do a volunteer job. For example, if you are going and getting training where you want to do in the IT profession, that definitely does not look good. If it is a tree planting society where you are going and volunteering, where you're planting trees, do you expect that you're going to have a job in tree planting in the future? Most probably not, unless you're a really professional tree planter. That's a different issue. It depends on if your intention is only to volunteer or if your intention is to get a future job from the same employer.
Vaibhav from YouTube asks, his wife is on H-1B, but he has the approved I-140. Should they switch her to the H-4 with the EAD so that they can save time on her H-1B 6-year limit? That's not a bad idea because she can always switch back to the H-1B in the future, and especially if her employer is not wanting to proceed with her own green card process at this time, it's a good idea to save up that H-1B time. You just have to be really careful with the transition from H4, from H-1B to the EAD, and make sure that you get the EAD approved in time so that you don't run out of H-1B time and have a gap in your employment authorization. But that's not a bad idea.
Question came in from Paul. He's asking the question whether his I-140 has been denied with employer A. Can he reapply with employer B? Absolutely. You need to file another PERM labor certification, of course, and then once it's approved, you can absolutely file with employer B. Not an issue at all. You may want to analyze why the I-140 is denied to make sure that next time it doesn't happen, that your I-140 the I-140 is not denied again. Question from Pradeep, how much time it's taking for the NVC to get approval petition once USCIS sends it? It's taking between 4 to 8 months to get the complete process if the priority date is current, so that the person can get the green card in the consulate processing.
Question from YouTube, can I join the new company after an H-1B transfer and resign from the old company later, 1 or 2 months later? Is there overlap going to be a problem? Yes, that is a problem unless the transfer was actually filed requesting concurrent employment. You can only work for one company at a time, so you do need to resign from one company and join the next.
Emily, I want your attention on this one. This is from Krishna Chaitanya. His H-1B has been revoked because of fraud by the company. Can he sue the company?
That's an interesting question.
I think so. He can. He should.
Yeah, I'm trying to think what cause of action you could put on that. Tortious interference of contract or employment?
No. Here is the thing. What I'm feeling is that you destroyed my life because you did fraudulent activity. That you should not be supposed to, especially we are noticing a lot of notice of intent to revoke for the cases that were filed in 2015 and 2016. If that guy wouldn't have filed a fraudulent application, this person should have been continuously working on F-1 visa, or he could have chosen to go to another company. I don't see any reason why he should sue the company, and it's easy to get the money from that company. Krishna, I would encourage that you should. I mean, that's the only way you can bring these fraudulent people down is by suing them in the court. It may be an easy victory for you, though, if you go and file a court case. They may not want to fight it. They may want to just settle with you outside.
Yeah, I think in the future. No, so there's no requirement for you personally that the company withdraw. It has no impact on your ability to come back in the future in any visa category.
Naveed has this question that he is born in India and his wife is born in Dubai. Though his wife is an Indian citizen, can he do the cross-country chargeability and file the adjustment of status going to the quota of United Arab Emirates? Answer to you, Naveed, yes. You can do that if your wife is, and their parents were living and residing in Dubai at the time when she's born there. Even though she's not an Indian citizen, you can apply the adjustment of status under the United Arab United Arab quota. So you could do one thing is that when you get the I-140 approval, or even at the time if the prior date is current for you on the I-140, you can file the adjustment of status and I-140 together. Though I would recommend to get the I-140 approval first in premium processing, because UAE is not running that much here and there as compared to India. I would recommend to get an I-140 approval and file the 483 application.
Banu from YouTube has a question. His wife's H4 EAD was recently approved. She's also applied for an H-1B in the CAP that's still pending. He wants to know if the H4 EAD will remain valid if that H-1B is approved. So it really depends on whether a change of status was requested in the H-1B filing. If the H-1B is approved with the change of status, then beginning on October 1st, she's automatically going to start H-1B status whether she wants to or not. If the H-1B was approved requesting consular processing, then it has no impact on the current H-4 or EAD status.
Debashish from YouTube has this question, Emily. I need your attention on this one. Will the home mortgage loan is going to have a negative impact on the totality of the circumstances? He's speaking about, Debashish is speaking about the poverty, the new regulations that have been issued recently, new ultimatum that is issued by President Trump, Emily.
Yeah, I mean, the public charge rule is really looking at have you actually used public benefits in the past? And if you have for 12 months or more, then you may be found not eligible for an extension of stay. But I think a home mortgage is not going to be an issue at all.
I'll be very, very surprised, though. You should be fine. Question from Vinod: why is the visa stamping getting delayed? Is this normal? He's speaking about the dates are being backlogged.
The interview dates,
and not only dates are backlogged, once you go for the stamping, they're taking. Well, right now, this administration is a delayed administration. Everything is delayed in immigration. H4 EADs are delayed, H1s are delayed, EB1Cs are delayed, EB5s are delayed. Everything is delayed. And it seems that litigation is some of the things that you can do, but although in the visa stamping, we still need to see any of the testings need to be done in a federal court on how that's going to be applicable.
Yeah, Arun has a similar question from YouTube. Attended the visa interview already on July 18th, received a 221G and no update since then, and wants to know if there's any way to get it expedited. And the answer is no. The consulate is going to take its own sweet time. It doesn't matter if the attorney follows up. It doesn't matter if the company follows up. It doesn't matter if a congressman follows up. They use national security as a reason to not expedite these things, and so unfortunately waiting and just continuing to keep up with the status and following up about every 30 days is all that can be done.
Question that came from YouTube is that, can I get an income through websites and YouTube? Is that legal? Karthik is asking the question. Karthik, if that is not part of the job duty, and even if you're getting directly income for yourself, not to your company, that definitely is a violation of the H-1B. I would recommend that you stay away from it.
Question from YouTube: what is the rule of 180 days and 240 days after the I-94 is expired when an H-1B extension is in process? So good question, and actually there is no 180-day rule. It's only a 240-day rule, and that's only if it's an extension with the same employer. So if you have filed a transfer, there's no 240-day rule. It's only an extension with the same employer. That means that if your extension is timely filed before your I-94 expires, and it's still pending when your I-94 expires, you can continue working for the same employer for up to 240 more days while you're waiting for the extension to be approved. That 240-day limit is not there for transfers. A transfer can continue working for the new employer as long as the transfer is pending under AC 21.
Emily, I need your attention on this Facebook question from Vikrant. I got my H-1B approved last week and I changed my employer on October 2nd. Do I need to provide the original approval notice? When should I initiate the transfer?
Yeah, we actually file a lot of transfers the first week of October. And you need, the copy of the approval notice would be helpful to show that you've been counted in the cap. If you at least have the receipt number, you can ask that USCIS look up the petition approval in their system. But yeah, generally that can be done. Now I would caution you that if you got your H-1B approved through an in-house fake project type company and with the plan that you would transfer to the company you've been working for all along, my answer might change. But assuming legitimately you got an H-1B approved that was for a valid job offer and you later got a different job offer and want to transfer, no problem with doing that.
Praveen has this question. He has his H-1B, he has a approved EAD and advance parole through adjustment of status. Can he work for another employer on EAD while working with the same company on the H-1B and EAD? Can he have a part-time job? Praveen, I don't see that as a problem. I think so you're fine if you have a part-time job. But I want to make sure that the part-time job also is also relevant to the profession for which you are on the adjustment of status EAD. I want to make sure that it's the same profession for which you are in. You can do a part-time job on EAD. However, you may lose the H-1B status and only remain on EAD if you were to choose to have that other part-time job. If you were to move completely to a different job, you have to wait for 180 days since the adjustment of status is applied, and then you can move to a completely different job. If you choose to do so, leaving your current employment, you have to file an AC-21, also called as 485J supplement form. And once you file that form, you could move from company A to company B, assuming the adjustment of status has been filed for more than 180 days.
Barani from Facebook has a good question. Is there any chance of USCIS stopping premium processing anytime soon? There's certainly a chance. They've done it a lot more often in the last 5 years than I think they ever had before. I think the chances of them doing it anytime soon is relatively less, just given the fact that processing times have actually been improving. Generally, when premium processing is stopped, it's because processing times for everybody else are too long and they need to adjust resources away from premium processing and help get the backlog down. But right now we don't really have much of a backlog or super long processing times on H-1 renewals or transfers. So I think it's not likely to happen in the near future.
Rayesh Ansari from YouTube has the question of the entire YouTube presentation I have ever done. He's an H-1B, he doesn't have a green card, he's not a US citizen. And is he eligible for the Social Security benefits once he returns to India after working 10 years in USA? Rayesh, as of today, yes, you are eligible for Social Security benefits, even if you return to your home country, even if you're not a green card holder, even if you're not a US citizen, you can return to India, you can claim the benefits as of now. That is the law. There are certain limited circumstances. For example, if you were to go and live in North Korea, I don't think so you can get it. There are very limited countries that are listed in there. Previously, Iraq and Libya was there. I don't think so they are in the list too right now, but I sure know that North Korea is still there in the list. India is not in the list, so if you go to India after 10 years of working, you would be eligible for your Social Security benefits.
Manan has a question on YouTube. His H-1B is approved. He's currently doing an MBA. And on the DS-160, it asks about the education details, wants to know if he should mention the MBA. Yes, you do need to mention all education, regardless of whether it'll accept the date in the future for your graduation. If you're currently in that program, you do need to mention that on your DS-160.
Shashi Karthik has a good question that he is an H-1B right now. His I-140 is approved. He's planning to go to Canada and stay there for 1 year as a multinational manager, wants to come back on L1A. And if the L1A is denied, can he switch back and come back on H-1B? Answer to question, Shashi, is yes, you can come back in H1B at any point of time. Even if your L1A is denied, you can still come back in H1B, and you are not subject to cap because you're already been on H1B. You already have your I-140 approved. You are not subject to cap. So you can try the experiment. If it works, L1B is a higher standard. A lot of people think that it's just like that. You get a L1A. No, it's not easy to get an L1A. There are a lot of hurdles to it, but the second plan that you have is that if the L1A gets denied, can you come back on H1B? The answer to the question is clearly yes.
Kuldeep from YouTube wants to know what content needs to be in an experience letter that you're going to be using for your green card process in the future. So USCIS wants to see that the letter is on company letterhead, issued by someone who's authorized to issue letters of employment for the company. They want to see what your job title was, your dates of employment with the month, date, and year, start date and end date, and your job duties that you were responsible for while you were there. Now, if your future green card process also includes a requirement for some sort of special skills and you gained those with this employer, those special skills should also be mentioned on the experience letter, which makes it a little bit tough because you might have to actually go back to the employer and ask for it to be revised sometimes. But generally, those are the requirements.
Emily, I want your attention. And the Sai Kiran from YouTube is asking this question. I have a bachelor's in electronic and communication engineering with 12 years of experience. How do I support the specialty occupation?
Well, I guess it depends on, is the question whether it's a specialty occupation, or is the question how are you qualified for the position? That would be my guess.
Yeah.
So, and I'm assuming that the position is not in that field.
The position is in the IT field, Emily.
Right. So, typically you look at what does the Occupational Outlook Handbook say is normally required for that job. So if it's a software developer, the OOH says most employers require a bachelor's degree in computer science. So you have to prove that you have the equivalent of a bachelor's degree in computer science. So you take your education documents, you get experience letters from all those 12 years of experience showing that you've worked in the IT field, and you get an education plus experience evaluation that gives you the equivalent of a degree that is required by the position, and USCIS generally does accept those, but you have to be very careful that all of the supporting documents are submitted with the evaluation. There's a very specific list. It's usually in the request for evidence, but we've seen a couple of denials lately. We've done consultations on cases that we didn't file where they basically rejected the evaluation because they didn't submit all of the documents that were used by the evaluator in making their decision.
Anything else, Emily, that you want to cover?
I think we are about out of time for today. I don't know if you have any last-minute questions.
Yeah, if you cannot address your questions, we do have a daily conference call. Don't hesitate to come to the daily conference calls. You can check our daily conference call timings at rahul@rnlawgroup.com, or you can make an appointment with me, Emily, or any of our competent colleagues. We have about 17 lawyers working with us. Everybody is competent. We train them. We train them, and they're well versed. Don't hesitate to make an appointment. All of our schedules are available online at rnlawgroup.com. And please don't forget to subscribe to Immigration News at immigrationgirl.com and also at rnlawgroup.com.
Thanks for joining us today.
Thank you guys for coming in.